Hello and welcome to Byjus Exam Prep. Welcome to day 2 of the knowledge series, and let's discuss the Attorney General for India. Attorney General is part of the Union Executive. Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. So Attorney General is an integral part of the Union Executive, but he is not part of the Union Cabinet. So that distinction should be clear to you. This Attorney General is the highest law officer in the country. Now, what does that mean? For example, you and me have a dispute, and I tell you, I'll see you in court, or you will drag me to the court of law. There has to be someone to defend me in the Supreme Court or courts in this country. And there is somebody who is going to defend you in the court of law. But what if the other party is the central government, is the union government? For example, 2019 Citizenship Amendment Act was passed, and there were many who challenged the constitutional validity of this law before the Supreme Court. Now, in the Supreme Court, who is going to defend the central government? Attorney General. Similarly, EWS reservation for those who belong to economically weaker sections of the society. Again, a petition was filed in the Supreme Court challenging the constitutional validity of this EWS reservation. And who is going to defend the central government in the Supreme Court? Attorney General for India. Now you might ask, sir, we also have Solicitor General, Mr. Tushar Mehta, defending the central government in various courts as well as in the Supreme Court. I'm going to tell you about the Solicitor General, but slightly later. So number one, Attorney General for India is the highest law officer in the country. What is the role? What is the responsibility? The role is that the President has assigned the Attorney General the duty to represent, to defend the central government in all the cases where central government is the party. But not just that. Article 143 of the Constitution. Now, what is Article 143? Presidential reference or advisory jurisdiction of the Supreme Court. The President of India can refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. That is what we call a presidential reference under Article 143 of the Constitution. For example, according to the Constitution, the judges of the Supreme Court and High Court shall be appointed by the President after consulting such of the judges of the Supreme Court and High Court as the President may deem it necessary. And while appointing judges, the President shall consult Chief Justice of India. Till 1993, the sole prerogative was that of the executive. The executive, the President and the central government would determine who is going to be the judge of the Supreme Court or High Courts, who is going to be the Chief Justice of India. But 1993, Sakara versus Union of India, Supreme Court's Advocates on Records Association versus Union of India, 1993 Supreme Court invented something called a Collegium system. Supreme Court said, from now onwards, Collegium, headed by the Chief Justice of India and senior judges of the Supreme Court, will recommend names to the President, and it shall be binding on the President to appoint these names as the judges of the Supreme Court and the High Courts. So India perhaps became the only country in the world where judges are appointed by themselves. But then in 1998, the President of India referred this matter to the Supreme Court. And which is this matter? Appointment of judges. The President asked the Supreme Court of India to please give your advice on the appointment of judges, because Constitution says something and your 1993 judgment says something else. So please give us your advice as to how judges can be appointed to the superior, to the higher judiciary. This is known as presidential reference, 1998. And who is going to defend the central government, or who is going to present the viewpoint of the central government before the Supreme Court when this presidential reference will be heard? The Attorney General for India. Long story short, Attorney General for India is part of the Union Executive. Attorney General is the highest law officer in the country. What is the job? Two important roles. Role number 1, to defend the central government before the courts of this country where central government is the party. Role number 2, to present the viewpoint of the central government where a presidential reference is made under Article 143 of the Constitution. And at the same time, let's look at the qualification. Who is qualified to be appointed as the Attorney General for India? Now, don't tell me this person should be an advocate or this person should be law-knowing individual. That's a given. But what is the qualification? Anybody who is qualified to be appointed as the judge of a Supreme Court is qualified to be appointed as the Attorney General for India. But remember, this person should not be a judge of the Supreme Court. No, because there is something called separation of executive from the judiciary. Judiciary and executive, they have to be separated from each other. So a member of executive cannot be part of judiciary. Member of judiciary cannot be part of the executive. So a judge of the Supreme Court cannot be appointed as the Attorney General for India. But who can be appointed? Somebody who is qualified to be appointed as the judge of a Supreme Court. And what is the qualification? Number 1, this person should be the citizen of India. If you are a citizen of India, then you have to meet either criteria 1 or criteria 2 or criteria 3. If you are a citizen of India, then you have to meet either of these criteria. What is criteria number 1? You should be a judge of a high court or one or more high courts for 5 years. If not, then you should be an advocate in one or more high courts for 10 years. If not, then in the eyes of the President of India, you should be a distinguished jurist. So what is the qualification? Anybody who is qualified to be appointed as the judge of a Supreme Court is qualified to be appointed as the Attorney General for India. Now, what are the qualifications required for someone to be appointed as the judge of a Supreme Court? Number 1, this person must be the citizen of India. And if you are a citizen of India and you are a judge of a high court or one or more high courts for 5 years. If not, you are a citizen of India and advocate of one or more high courts for 10 years. If not, you are a citizen of India and in the eyes of the President of India, you are a distinguished jurist. These are the qualifications required for somebody to be appointed as the judge of a Supreme Court, and these are the qualifications for someone to be appointed as the Attorney General for India. And it shall be the duty of the Attorney General to give advice to the President on all legal matters. This is where we come across third important role of the Attorney General. What is this advice? For example, the central government has to impose President's rule under Article 356 of the Constitution in the state of West Bengal. Now the President or the central government will seek the advice of the Attorney General. Can we impose President's rule in West Bengal? These are the grounds on the basis of which we want to impose President's rule in West Bengal. Do you think these are sound, valid, legal arguments, legal grounds on the basis of which we can impose President's rule? This advice will be given by the Attorney General to the central government. One more example. For example, a major change was made to UAPA, Unlawful Activities Prevention Act, according to which now even an individual can be designated as a terrorist, because previously organizations would be declared as unlawful, organizations would be declared as terrorist organizations. Now even individuals can be declared as terrorists according to UAPA, which was amended in 2019. Here also advice is given by Attorney General. Is it legal, constitutional to declare an individual as a terrorist? So the third important role played by the Attorney General is that he can give advice, sound legal advice, to the central government whenever central government is seeking his advice. That is role number 3. Let's look at something else. Important points. I told you that you should be eligible or qualified to be appointed as the judge of a Supreme Court in order to be eligible to be appointed as the Attorney General for India. But you would also know, and I'm sure you know this, that there is an age limit. The judge of a Supreme Court holds office till the age of 65. And at the age of the 65, the judge of a Supreme Court retires. Who is the Attorney General for India today? Mr. K.K. Venugopal. And Mr. K.K. Venugopal is aged 90. How's that possible? If you're qualified to be appointed as the judge of a Supreme Court, then you are qualified to be appointed as the Attorney General for India. But at the age of the 65, the judge of a Supreme Court retires, which basically means you are not eligible to be appointed as the Attorney General for India if you're above 65. But this age limit of 65, which is for the judges of the Supreme Court, it does not apply to the Attorney General for India. That is why Mr. K.K. Venugopal, at the age of 90, continues to defend the central government solidly before the Supreme Court and various courts in this country. Important point. Another important point, which we have discussed previously, is that Attorney General is part of the Union Executive, but he is not part of the Union Cabinet. Another important point, Doctrine of Pleasure. Attorney General for India is appointed by the President of India, but President does not have a discretion here. Any name which is recommended by the government, which is recommended by the Prime Minister and his Council of Ministers, is appointed as the Attorney General for the President of India. But for how long? 1 year, 2 years, 3 years, 5 years, 10 years? This tenure is not defined in the Constitution. What is going to be the term of Attorney General is not defined. And normally, Attorney General is appointed for a period of 3 years, but this term is not mentioned in the Constitution. This tenure is not mentioned in the Constitution. But even before 3 years, sometimes extension is given, because Mr. K.K. Venugopal was given extension. But sometimes, even before completing 3 years or 2 years or 1 year, the Attorney General for India may be removed from his office. And for that, the President will have to just issue an order and remove Attorney General. And this is what we call Doctrine of Pleasure, which means the Attorney General for India is appointed by the President on the advice of the government and shall hold office till he enjoys the pleasure of the President, which basically means the pleasure of the central government. As long as the central government is satisfied with the Attorney General, he continues. And the moment this Attorney General loses the pleasure of the central government, loses the pleasure of the President, this Attorney General can be removed. And there is another convention. What is the convention? Unwritten rule. Something which is not mentioned in the Constitution, but something that we follow. And what is that convention? Attorney General is appointed by the central government to defend the central government in the courts of law. Whenever there is a change in the central government, the Attorney General submits his resignation. This is a convention. This is not a written rule. This is not mandatory. This is not binding, but this is a convention. If I am appointed as the Attorney General by the current government, and if this government changes, I will submit my resignation to give an option to the central government. Now you can appoint your own individual, any person, as the Attorney General to defend you in the courts of this country. But this is a convention, an unwritten rule. This is not mandatory. And at the same time, his remuneration is decided and determined by the President of India. Again, this is something which is not mentioned in the Constitution. Let's recap. Attorney General for India, part of the Union Executive, not part of the Union Cabinet. Attorney General for India plays 3 important roles. Number 1, defends the central government in the courts. Number 2, defends or presents the viewpoint of the central government when a presidential reference is made under Article 143. And number 3, gives legal advice whenever it is sought by the central government. 3 roles. What is the qualification? If you are qualified to be appointed as the judge of a Supreme Court, you are qualified to be appointed as the Attorney General for India. And this Attorney General is appointed by the President on the advice of the government, and he holds office during the pleasure of the President. And the remuneration is determined not by the Constitution, but by the President of India. Let's look at something else. There are some privileges which are available to Attorney General for India. Attorney General enjoys all the privileges, all the immunities which are available to the members of the Parliament. We will discuss hopefully slightly later what are the privileges which are available to the members of the Parliament. Whatever privilege is available to the member of the Parliament, those privileges, immunities are also available to the Attorney General for India. There are a few more privileges. Privilege number 1, he has the right of audience in all the courts in the territory of India. What does that mean? You and me have a dispute. We approach the court, for example, Karnataka High Court. Karnataka High Court is hearing our case. The Karnataka High Court will hear you as well, will hear me as well, my lawyer, your lawyer. What if someone else walks in this High Court and says, "Dear High Court, please hear me"? The court will ask, who are you? How are you connected with this case? Are you an aggrieved individual? Have your rights been violated? Are you connected with this case in any manner? If not, then what are you doing here? We will not hear you. That means a right of audience is for those who are the parties to this case. You and me have a dispute. We will approach the court. The court will hear both sides. If the state government is on the other side, central government is on the other side, the court will hear all the parties to this case. But what if you and me have a dispute and this dispute is heard by the Karnataka High Court and suddenly Attorney General for India walks in and he says, "My lord, hear me out, I have something to say on this case." The court will not ask him, who are you? How are you connected with this case? What is your locus standi? Are you an aggrieved individual? No, because the Attorney General has the right of audience in all the courts within the territory of India. He can walk into any court in this country and the courts will have to listen to his side of the story, will have to listen to his argument. This is a privilege. Privilege in the sense, Attorney General is not part of this case. Even if he is not part of this case, the court will have to hear him because he has a privilege, and the privilege is the right of audience in all the courts within the territory of India. Privilege number 1. Privilege number 2, UAPA, and even before that, National Investigation Agency Act. These were being debated in the Parliament, particularly in Rajya Sabha in 2019. Mr. P. Chidambaram, the then Rajya Sabha member, he got up, he spoke, and he made a request inside Rajya Sabha. The request was, please ask Attorney General to come inside Rajya Sabha and we will pose him certain questions. What is he asking? He is asking a non-member, who is not a member of the Parliament, to come inside the Parliament, sit inside the Parliament, speak inside the Parliament, answer questions of other parliamentarians. How is that possible? This is possible because this is another privilege available to Attorney General for India. He can come inside the Parliament, sit inside the Parliament, speak inside the Parliament, become a member of a parliamentary committee as well, except one thing, he will not have the right to vote. He can come inside Parliament, speak inside Parliament, become a member of a parliamentary committee, but he does not have the right to vote. Why? Because he is not a member of the Parliament. But despite the fact that he is not a member of the Parliament, he has a privilege. And the privilege is he can come, sit, speak, become a member of any parliamentary committee. That's another privilege. Something else. This Attorney General for India is not barred from private practice. I am an Attorney General, but I can also take up private cases. But there are some restrictions when I take up private cases. Restrictions such as, I cannot defend the accused in criminal case without the permission of the Government of India. One limitation is, if I am an Attorney General for India, I can take up a private case, but I can take only those private cases in which the opponent is not the central government. There is a case between you and me. I can ask Mr. K.K. Venugopal to defend me in the court of law. Why? Because this is a private case. But what if there is a case between me and the Union of India? I cannot ask Attorney General to defend me. Why? Because the opponent is the central government. That's one limitation. That's one restriction. That means Attorney General can take up private cases if the opponent, if the other party is not the central government. And this Attorney General cannot even take up criminal cases without the permission of the central government. I don't know whether you know this, but very briefly I'll tell you what is the difference between a civil case and a criminal case. A civil case is one which is a dispute between two individuals. Civil case, dispute between you and me. Two individuals, it's a civil case. But in a criminal case, it's a dispute between an individual or an institution and the other party is the state. Now the state can be central government. This state can be state government as well. State within the meaning of Article 12. And the Attorney General cannot defend an accused in a criminal case without the permission of the central government, without the permission of the President of India. What if this criminal case is against a particular state government? He can defend the accused, but only with the permission of the central government. I'll give you one example. A few years ago, Mr. Mukul Rohatgi, he was the Attorney General for India, and he defended the bar owners of Kerala against the Kerala government. How? Because it's a private case involving a state government and the bar owners. He defended the bar owners against the state government with the prior permission of the President of India, prior permission of the central government. That means Attorney General can opt for private practice, if the other party is not the central government, can defend the accused in a criminal case, but only with the permission of the central government. And he does not fall in the category of government servants. When he doesn't fall in the category of government servants, that means this person is not the employee of the central government. And I told you about Tushar Mehta, the Solicitor General of India. Attorney General is assisted by Solicitor General of India and various additional Solicitor Generals. That means since Attorney General himself cannot take up all the cases in which central government is the party, he needs some assistance, and that assistance is given by the Solicitor General and additional Solicitor Generals. But additional Solicitor General and Solicitor Generals, these are not mentioned in the Constitution. That means these are extra constitutional posts. Only the Attorney General for India is a constitutional post. He is assisted by Solicitor General and additional Solicitor Generals, any number appointed by the government of the day, but these are extra constitutional posts. The only post which is constitutional is the Attorney General for India. Now you might ask, sir, what type of questions can be asked in prelims examination regarding this topic of the Attorney General? Let's look at two questions so that you have an idea. Question number 1, which was asked in 2013, and question number 2, which was asked on Sunday, Prelims 2022. Let's discuss both these questions and you will have to tell me the answer to these questions. Look at the question. Consider the following statements. Attorney General of India can take part in the proceedings of the Lok Sabha. Now, why have I mentioned Attorney General of India, whereas it is Attorney General for India? It's because the UPSC Prelims question paper asked and mentioned Attorney General of India. But it is not Attorney General of India, it is Attorney General for India. Let's look at the question. He can take part in the proceedings of Lok Sabha. We have discussed, yes. He can be a member of a committee of Lok Sabha, yes. He can speak in Lok Sabha, yes. But can he vote in Lok Sabha? No. Why? Because he is not the member of Lok Sabha. So which of the given statements are correct? 1, 2, 3. C is the right answer. Let's look at the question asked on Sunday, Prelims 2022. Consider the following statements. Attorney General of India, again UPSC has used of India, whereas it is for India. Attorney General for India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. I told you only the Attorney General for India is a constitutional post. Solicitor General and additional Solicitor Generals, these are extra constitutional posts. And the privilege is only for the Attorney General, that he can participate in the meetings of Parliament, speak inside the Parliament, become a member of a parliamentary committee. But this privilege is not available to the Solicitor General. That is why statement 1 is incorrect. Statement 2, according to the Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. I told you this is a convention, an unwritten rule, not mentioned anywhere in the Constitution. So if the statement says according to Constitution, but it is not mentioned there, that means the statement 2 is incorrect. Which of the statements given above are correct? D. Neither 1 nor 2 is the right answer. And that brings us to the closure of this lively discussion on the Attorney General for India. But now I'll take some of your questions so that all the doubts related to this topic are resolved. But before that, you have to press the like button. You have to subscribe to our channel if you haven't yet. And you'll have to share the links of these classes with your friends and fellow aspirants. And once the live session is over, drop in your comments. Let me also read what you have to say on this beautiful knowledge series. Questions, please. Sir, how to remember all articles of the Constitution? Simple answer, you do not have to remember all the articles of the Constitution. Full stop. What are the limitations on the Attorney General? I told you the limitations are that he can take up private practice, but the opponent should not be the central government. He can defend an accused in a criminal case, but with the prior permission of the central government. Who appoints Attorney General and Solicitor General? Appointed by the President of India. Can Attorney General for India become a Supreme Court judge after he has resigned as the Attorney General? Yes. So how to prepare for 2023 prelims? Subscribe to Byjus Exam Prep YouTube channel. Attend all these videos that we put out. There is going to be a workshop this Saturday on Byjus Exam Prep app. Please attend and watch that session. You will get and gain tremendous insights into how to prepare for Prelims 2023. So please attend that workshop. We'll discuss in great detail how to prepare for 2023. Do we have more questions? Can you scroll down, please? The document. Okay, that is it for today. Tuesday morning. Thank you for being with us. Have a safe, beautiful day. All the best. Bye-bye. Take care.